Let's do it. All right, let me make sure I got the rest of my stuff half-ass squared away, which I normally never do. You guys know me already. Um, and now that we're live, we'll give it a minute, see who shows up, and then we'll do this thing. Let's see. There we go. I had to wait for that to come up so I could mute that. And we are definitely going to roll this out. I did not know these oral arguments happened today. I'm not plugged into where people call me and say, hey, these oral arguments for today, as much as I stream stuff. So, I kind of got to catch up on the fly. What's up, Sam Anarchy? What's up, my brother? Hopefully everything's going good. So we're going to stream these oral arguments tonight. Oh, man. It's coming out of California. I would expect all share the pain rules to be in effect. Seat and tray tables, upright position. Anything that's loaded, at least a little bit out of arm's reach, so you might have to stretch to get it. What's up, Damien? Again, I'm not responsible for shot TVs, thrown phones, shot computers, anything like that. That's all on you guys. But we're going to see, because I haven't listened to these arguments yet. Matter of fact, let me show you guys. Let me do a screen share real fast. And I'll kind of show you guys, because I just saw these. Coming straight from my brothers at the Firearms Policy Coalition. California argues it doesn't ban gun shows on state property. It just bans guns and ammo sales from taking place on them. So apparently I could show guns all day long. I just can't sell them. Can't transfer them. That's nice. So that's how I found out about this. And I forget exactly when they posted that, but it was sometime today. So anyway, that's what we're going to listen to. But I haven't run it in a while. Sparta!
Hey, boys! Look what I got here!
Hey, where are the white women at?
All right. I had to run the intro, man. I haven't run the intro in a couple shows. And I've got to work on something shortly to kind of redo that intro a little bit. I've been using it for a while, but I like it. So, hey. All right. Let's see. Let's add this to stage.
Come back again you are. Yeah.
And let's do
it. Please just stay where you are, and counsel, you can come up when you're ready and proceed. Thank you.
This, matter of fact, I got to check. This may be only the second oral argument. Either way, we're listening to it.
And we haven't forgotten everything you said.
Yeah.
So
exactly.
Yeah, apparently this is second. Their link only showed the second. Let me know whether you want to reserve any
time for rebuttal, but we do have your arguments from the first case. So
while we're doing that,
let me clarify that. I will. May it please the court. Again, Anna Barber for B&L Productions et al. I would like to try and reserve 2 minutes, if I may. In 2019, 2 years before the events that gave rise to the challenge in the Orange County case we just discussed, California banned the sale of all firearms and ammunition. It later added firearm precursor parts at the Del Mar Fairgrounds only in San Diego. While the law there did not expressly ban gun show events, banning these events and the speech that takes place there was the law's purpose and effect. The question presented here is similarly to the Orange County case.
I saw that. I'll read that in a second.
California's eradication of this long-standing avenue for lawful commerce in arms can withstand constitutional scrutiny. The answer is no, under both the First and Second Amendments. But this case is even simpler than that. This case is before this court on a dismissal of BNL's claims on a Rule 12 motion to dismiss.
I'm only seeing the
and
one,
only after
not
the
the
court
other.
assumed facts that weren't in evidence.
So I might have to do some digging. Tim, what's up, brother?
Were not part of AB 893.
So, and let me fill everybody in. So, apparently, California, and their infinite fucking wisdom, being the anti-gun douchebags that they are, basically said no gun shows on state property. So, fairgrounds, trade centers, stuff like that. In some of their laws. And I'd have to look up the exact case. I haven't looked it up yet because, like I said, I just heard about this today and that the arguments were going on. I'm not completely familiar with the case. But that cuts out a lot of places where normal gun shows go on, like the Trade Center downtown in Columbus where they hold gun shows, or any of the fairgrounds around that area. Because it's all basically state-run property. The same would be true in Alabama at a couple fairgrounds in Alabama. If Alabama said, hey, you can't do gun shows here anymore, and these are pretty large gun shows in a lot of cases. So this is being argued through the courts that, hey, the government can't, and I'll guarantee you, I haven't listened to the arguments yet, but I'll guarantee you this is being argued under, this is constitutionally protected, and the government can't stop you from doing a constitutionally protected event. So we're going to listen to it and see, but that's kind of the basis of this from what I understand. Like I said, I just found out about this at like 5 o'clock or so when I got home, and was able to run through my X feed and actually see Firearms Policy Coalition posting about this.
Disregarding the well-pled facts of BNL's first amended complaint, that they in fact had been restricted and barred from getting gun show events on the calendar. And finally, in the case of the Second Amendment, failing to conduct any historical analysis that Bruin would require. This court should reverse. I want to first, I think, talk a little bit about why speech is in fact addressed and covered by AB 893. The record in the trial court in Orange County, you would see this was a substantial question. It took up a lot of time during the parties' oral
Let me
presentation.
know whether the audio's good, whether you guys can hear everything good.
Its
Hold
first
on,
and
y'all.
most obvious example of speech being restricted, of course, is that the fairground staff did in fact refuse to contract with BNL to host or calendar gun shows at both Del Mar Fairgrounds and the OC Fair and Event Center since the laws took effect. The state talks
and are you
about
talking about gun shows without the sale of guns? So you're talking about the interpretation of the district of these laws in a way that would bar the scheduling of all gun shows, even if there was a limit on the sale and purchase of guns?
Yes, Your Honor. There not only was it in the allegations of the first amended complaint in Del Mar, it was the allegations of the complaint in Orange County, but there is a declaration from Tracy Olcott, who is BNL.
Good deal, Tim. Thanks, brother.
Productions. She is the conduit between OC Fair and Events and the Del Mar Fairgrounds and Crossroads.
So are you seeking relief? I asked your opposing counsel in the first argument this question, but I didn't.
And I got, like I said, I got to find the first argument. This was the link off of FPC's X post, and this only started out with this part of the oral argument. But it all comes down to speech is constitutionally protected. Second Amendment is constitutionally protected. Those are Second Amendment activities, First Amendment activities, and the state should not constitutionally be allowed to ban people from engaging in those activities on state grounds. So, and I completely agree with that. Now, understand, this is the arena we're stuck in right now. Most of these cases should never survive the state challenges because no state that I am aware of has anything in their state constitution that says the state has, one, the right to regulate arms, or two, the right to regulate speech and other constitutionally protected activities. What's up, Tactical FUD? What's going on? Even California, people say, well, California has no Second Amendment in their Constitution. Well, it doesn't. But it also does not have a section in that Constitution that says, hey, the government gets to regulate these things. And for those of us who actually believe in these constitutional restraints on government, if that power is not enumerated to the government in that document, then guess what? That government doesn't have that power. Anything that's not enumerated, anything that is not spelled out in that Constitution is left up to the people. And the government doesn't have the right to control it. That's where I'm always going to come from. And again, most of these things should not survive state challenges. And the federal Constitution shouldn't even come into play because federal Constitution governs federal matters. This is a state matter. However, our legal system is so screwed up these days, and we have so many leftist judges that we have to deal with stuff like this. So inevitably, it works its way up to the federal courts. This is in the federal courts. This is the Ninth Circuit, I believe, which always makes things better.
Have an opportunity to ask you, assuming that we reject your facial challenge, is your view that you would be satisfied with an order enjoining the law as interpreted by the district to bar gun shows where there are no sale of guns? Because the way I read your complaint is that there's no financial incentive to have these gun shows if there isn't, people don't come and businesses don't want to be there, vendors don't come if they can't sell guns. So I just, I don't see anything in your complaint in which you seek relief specifically as to an as-applied challenge.
No, BNL, none of the appellants would be satisfied with an as-applied construction that would allow they're going to call them gun shows that don't allow gun sales. That's not.
Okay,
that's not a thing.
So the
gun
allegations
shows allow gun sales.
So the allegations you're making and the relief that you're seeking is really for the whole shebang, not for the gun shows.
Correct.
Without the sale of guns.
Yeah, gun shows without the sale of guns are not a thing. That is an event, an entirely different event. That is not the business model of my client. That is maybe an educational event about, guns. It's not a gun show. Gun shows involve commerce in arms.
So we went through this when I was
Legal
trying to pin
commerce
down
in arms,
the
by the way.
state's position. And it appears not to be contested that there is going to be a waiting period, so there wouldn't actually be delivery of firearms at the fairground.
Correct.
What is your understanding?
DJ, you wussy.
What
What's going on, brother? I completely
state
understand,
will
man.
permit that makes the statute objectionable?
It would have.
If we understand that the state has taken the position that the offer for sale can be made and the parties can talk about it, and either way, the gun doesn't get delivered until after the waiting period at some other location, I'm having trouble figuring out just what the difference is here.
This assumes, again, that the state is telling you the truth about what it believes the law does.
Well, see, if we're taking this as a facial challenge and we say, this is what the state says it is, this is what it is, what's wrong with that from your perspective?
Can I read you the record?
Well, see, I'm not so much concerned because this is a facial challenge. And
If it's a facial challenge, which means we're not digging real deep into this. This is what the state said. This is what this does. If it's a facial challenge, how could you not be concerned with what the state said? Again, these people are judges appointed to a bench. They should absolutely be impeached. But we live in clown world.
parties, I see lots of cases where parties' positions evolve over time. We're concerned about what is it we're supposed to do with the challenge, and the facial challenge is now articulated in such a way, I'm having trouble figuring out not what position the state might have taken. I know the state's going to say it didn't take that position. I don't really care very much. I'm concerned about a facial challenge now, and if the state has conceded that it will permit the offers for sale, where's the problem?
The state hasn't conceded that. It has rejected that position.
Well, I was sitting here in the last argument, and you were too. We heard what the state deputy attorney general said. What in the line that he sought to draw is problematic from your perspective?
This should be in my feed. I subscribe
If
to
all
all
the
this shit.
speech is allowed, if they're allowed to advertise, they're allowed to offer, they're allowed to accept the offer, negotiate terms, I mean, then I guess
the one piece I may have to go back and pin down, I was focused on the offer side and the negotiate side. And it was explained, but I didn't pick it up quite so much, that the background check is triggered with the entry of the agreement. So maybe I need to work on that with the state, and he has now a warning that we're going to get there. Let's take that either way. If the state's position is you can offer, you can talk about, you can have your display, you can't deliver, that's not contested, and you can't sign the credit card slip that triggers the background check, that may be a bone of contention. I get that. Is that the only bone of contention we're at this point? If in fact the state will allow the display, the offer, the discussion?
if that is what the state is allowing, that's what it's always allowed, and so gun shows can take place. I don't know then why the OC Fair and Event Center and the Del Mar Fairgrounds refused to contract with my client to have gun shows, even when they agreed that they wouldn't do any kinds of sales transactions. That would probably be something you have to determine in the trial court with evidence. That didn't, that couldn't happen in the Del Mar case because it was on motion to dismiss.
Why does it matter anymore? If in fact this is a facial challenge and we ascertain either there's no difference between the parties or a thin difference that we may have to adjudicate, I'm trying to figure out what's there for the facial challenge today.
Again, if the state's position now is that all of that speech can happen and all of those transactions can happen, then this is back to where we were before the laws were passed.
I just gotta find it.
And
I think I've
Del
got
Mar
the
would be
right.
having gun shows again, and
Well,
we'd be happy with that.
Your papers have taken the position that without the actual sales, these things are economically not feasible. I don't know that that's a position you're going to continue maintaining today, but I've read that someplace in the materials. And so I'm not trying to say that the parties haven't gone back and forth and altered positions and recognized events.
All right. I think I found the first part of this. I'm going to have to stream it off of YouTube, but I think I found it. So we'll switch gears. We'll go back to the first one, then we'll crank this one back up where it was at. Because they're talking about a lot of stuff in the first one in this, and it annoys me when I don't have the first couple chapters of the book. So let's see. Let's do a different. Mr. Nice, what's up? Should be no, it's not that one. It's this one. All right, this should be the first part of this. Yeah, because this is against Newsom. The other one, okay. So, all right. And again, this is from today. So let's listen to this one. And sorry to switch gears, guys. I didn't understand the order on them at first. So forgive me. I'm a fuck up. What do you want? So for anybody coming in, and I haven't looked at the entire cases yet, and I'm a nerd when it comes to this stuff, and it kills me. California basically making a ruling or a law, ordinance, whatever, that you couldn't hold gun shows on state-owned property. Okay. Gun shows, Second Amendment, firearms, you name it, speech, are all constitutionally protected. There should never be a time where the state can tell you can't do constantly protected things on their property. Things, for lack of a better word, I understand that sounds retarded, but they shouldn't be able to tell you you don't have constitutional rights when it comes to being on state property, or you can't hold a constitutionally protected event on state property. The state should never be able to tell you that. Believe it or not, you statists out there who think the government should be able to do that, the people are the ones that are supposed to have the power over the state. They are the ones who actually own the state property. So whether or not the government likes a constitutionally protected thing, they should never be able to stop it. So that's where we're going to get into this. Max goes up to the 9th, 318. Dude, yeah. Remind me of that, because we got to cover that. So Mr. Knives, we got to cover that 100%.
Yes, thank you.
Good morning, and may it please the court. Charlie Sorosi on behalf of the state appellants. I'd like to reserve 3 minutes for rebuttal.
Thank you.
Yeah,
It is the appellee's burden to demonstrate that SB 264 and SB 915 trigger the First Amendment and the Second Amendment. Under longstanding Ninth Circuit precedent, they failed to meet that burden. At issue in this appeal are two laws whose plain language shows their limited scope. SB 264 and SB 915 merely prohibit the sales of firearms and ammunition on state property, including the Orange County Fairgrounds. As this court has long held, a sale of a firearm is not speech, and the First Amendment does not even come into play. These laws do not prohibit the activities that appellees claim are the primary reasons that people attend gun shows, such as participating in gun culture and engaging in speech about guns. Nor do they prohibit the sales of products that over 60% of vendors at gun shows exclusively sell, such as camping gear, clothing, and food, among others. The plain language does not bar gun shows, which can still occur on state property, just without firearm and ammunition sales. The plain language also does not prohibit.
Try to be clear about that, because I've gotten confused. There are at least some allegations that in particular instances, the proprietor, B&L, wasn't allowed to have a gun show limited to the speech elements, that is. So I just want to be clear in understanding the state's position with regard to what you believe B&L is allowed.
You got to love the way the state
or any of their
they always argue it as
is
we win, you
allowed
lose
to
no matter
do,
what.
and the state is obligated to permit them to do on the state properties. And this actually, I mean, we got two cases, but it's much the same issue. So I'm not trying for, I'll let everybody know, I'm not trying to limit my questions to simply one. It's the broader concern, because these are really policy attacks.
Especially with the Ninth Circuit.
So what is it the state
Seventh Circuit
understands it is obligated to permit?
A gun show without sales of firearms and ammunition is permitted on state property.
Oh, Morris, what's up, my brother?
And the Central District Court overlooked a declaration from Jennifer Olvera from the District Agricultural Association there. And that declaration is at 2ER 201.
Okay. And I'm going to try not to pause this too much, because like I said, this is the first time I've listened to this. And it typically takes me about 2 times, maybe 3, listening to some oral arguments to really come up with some really coherent thoughts and some good questions. But a normal gun show, okay, you come in and you have vendors there who are selling firearms and firearms related products. That's our understanding of a gun show. Okay. Something like SHOT Show, which is a completely different story, which is just there to showcase items, is completely different. That's a more trade and industry focused show. If I go to a car show could do either one. They can just show cars and not sell, or they could show cars and sell cars. It's a little bit different event. But for the most part, gun shows, you expect to be able to go to a gun show and actually practice your constitutionally protected rights, owning firearms, buying ammunition. If you can't do that at a gun show, then it's not really a gun show, it's a gun show off.
Don't start wildfires.
Don't start wildfires. Apparently she's hooked on wildfires right now.
And that declaration says that the District Agricultural Association would coordinate with Crossroads to schedule gun show events consistent with the law. And then in the Southern District case that is being heard after this one, there's also a settlement agreement from a prior case between the district and between B&L Productions, where the district agrees that it, in that settlement agreement, that it will coordinate with Crossroads on gun show events consistent with the law as well. So I think in the record in both cases, you have evidence that the respective district agricultural associations would schedule gun shows with Crossroads.
Right, where is that in the record in the Del Mar?
In the Del Mar case, that agreement is at 2 ER 234.
Thank you.
And did B&L ever, I think this is a sort of an extension of Judge Clifton's question, was there ever a request for relief specifically for the district to allow for gun shows or to interpret the laws in a way that would allow for the gun shows without the sale of guns? Was there ever any sort of request specifically for relief that would be, essentially an as-applied challenge versus the sort of facial challenge that they focused on?
I think there are vague allegations about a request in the complaints in both cases about a request from B&L to the district that they have a gun show without sales, and then the district
I'm back.
But that doesn't overcome the evidence in both cases saying that the district for either the Orange County Fairgrounds or the Del Mar Fairgrounds would hold a gun show without sales consistent with the laws applicable at the time. And so that's, again, based on the plain language of the statute, that this only bars sales. And this is not like the there's a 2019 case involving B&L Productions against the 22nd District Agricultural Association at the Del Mar Fairgrounds. And that is very different from this case because that policy on its face said no gun shows for 1 year. And that is not what these laws do. These laws, their plain language says no sales of firearms and no sales of ammunition, and gun shows.
So you can have a gun show.
And so what they're seeking
But
as
you can't have a gun
relief
show.
is an injunction of the law in its entirety so that they can have the sales at the gun shows, not just to have the gun shows.
Correct. I think they primarily mount a facial challenge in both of these cases. And the focus is
The amount of
I
mental
think as the Central
gymnastics
District Court
you have
did,
to go
they think
through
that,
for this is
or their
insane.
position is that sales means you're restricting commercial speech. And that is what the Central District agreed with when it said that legislation restricting sales also restricts commercial speech. And that is contradictory to this court's decision in Nordyke 1997, where it clearly made a distinction between a restriction on sales, which is not commercial speech, and a restriction on offers for sale, which is commercial speech. And the contract lease addendum in Nordyke 1997 not only barred offers for sales, it barred any act to initiate a.
So I can have a gun show and I can offer to sell you a product, but I can't sell you that product. Okay. There's a whole lot of women of the night who would love this argument. I only offered to sell it to them. I didn't.
Transaction. And these laws don't do that. Again, they just bar sales, which means that
Matt, what's up,
dealers
brother?
and ammo vendors can promote and display and exhibit their
That
products
would be a
at gun shows.
good
It's
question,
just the
Matt.
sales that cannot be done at these gun shows. And that was our
Can I
primary
show you a
argument in the
picture
Central
of the
District
gun,
Court case, and that I think was
and then you
overlooked by
turn
the
that
district
picture
court,
in for the
there.
gun later?
And
Well,
I
it
think
is true that there were advocates. There were multiple bills here, and I confess I've lost track of which statements pertain to which bill. But there were statements by members of the legislature supporting bills that spoke more broadly and tried to proclaim there will be no more gun shows. What do you say to that?
I think when you look at the context of those statements, they're focusing on the sales rather than the gun culture or the speech about guns that happens at gun shows. And I think under the Supreme Court, as it recently said in Dobbs, and as this court said in Nordyke 2011, what matters is the plain language of the statute and the stated interest in the legislative findings. And the stated interest and the plain language shows that this is about sales, not about
stated
speech,
interest and plain language are two different things.
Read or void a statute based off of statements by individual legislators, even if that individual legislator is the author. And that, I think, Nordyke 2011 is very on point with
the whole spirit
because
of
that
the law
also involved a
argument.
county supervisor who made a series of statements that potentially showed some kind of animus towards gun culture. And there, the court said we need to focus on what the statute does, not on the statements of one legislator, even if that legislator was the one who.
But they will argue the exact same thing.
Issue. So
Opposite.
I would focus on the language of the statute
for something else.
And the studies, I think, for SB 915, which is the one that prohibits sales on state property, those bill analyses all talk about straw purchasing or illicit transactions, and the legislative findings in AB 893, which is the Del Mar Fairgrounds, and in SB 264, which is the Orange County Fairgrounds. They also speak to the harms that arise from sales in the setting of a gun show, which are temporary marketplaces, whereas plaintiffs say thousands of people get.
Okay, but in any state, in any case that I've ever heard of, you can only point to less than 1% of guns used in crimes that are purchased from a gun show. Right now, you want to argue on the strict text of the law. It's going, Ag. It's really going. Right now, you want to argue on the strict text of the law and just fuck the intent that person had, even though they stated their intent. But in other cases, you want to argue that this statute doesn't cover something, but it was the intent of the statute to cover it.
Words of the day: don't cuss around little kids.
You're not supposed to be in there anyway. Go do your homework. They always play this game, and no matter what, the state wins and you lose. Always. 500, what's up, my brother? Yeah. California never relents, man.
Gather, and there are several vendors. So I think that setting especially lends itself to the sales of illegal weapons and the sales of weapons to prohibited persons, as well as straw purchasing. And
Brother 500, hopefully you're doing good today, man.
Somebody else goes to buy an item, but it's actually not for themselves or giving it to somebody else, usually a prohibited person. And so I think, again, the statements in all, across all three bills, it's focused on sales, and we need to focus on the plain language in all the bills. And I think no matter which way you look at plaintiffs' First Amendment theories, they fail across the board under the Nordyke.
Dude, I'm living the dream.
Again, in 1997,
I just got to figure out whose dream it is.
A sale is not commercial speech.
And then I'm going to find
that
out
was
which one
confirmed
it
in
is.
Nordyke 2003.
Well, a sale isn't, but here we have a situation where, because of other legislation, the sale can't be consummated at the gun show, and B&L hasn't disputed that. And they argue, and I think that the Central District decision, although again I'm maybe getting them mixed up, the Central District decision highlighted the commercial speech concern, saying that the offer to sell was commercial speech, and that's the one piece that the state won't permit to happen at the sale-free gun show or the alternative gun show, which you say the state is willing to let happen. The one thing they can't do is actually offer to sell anything, even though the sales wouldn't be consummated until after the waiting period and background check and delivery would be made elsewhere. So why isn't that a concern about a restriction on commercial speech?
I think our position in the district court briefing and the briefing before this court is that offers for sale are permitted because these laws do not bar offers for sale. And so I think we've said in our briefing that, the promotion, exhibiting, display, advertising of prices, and marketing of firearms and ammunition is permissible.
But the only thing that's prohibited is the acceptance of that offer to be delivered sometime after the background check and so forth.
Yeah, it's as Nordyke 1997 said, is the act of exchanging money for a gun, or it's the initiation of the background check process, the penal code statutes that.
Okay, so this is how retarded we get in some of these things. And I had to look it up real fast. I was pretty sure, but I had to look it up. So in California, there is no strict person-to-person sale. If I want to sell someone a firearm, to be legal, I have to bring that firearm to an FFL and have that firearm transferred through an FFL. That person still has to go through a waiting period to receive that firearm. They still have to go through a background check to receive that firearm. Okay, the people doing person-to-person sales without background checks in California already ain't worried about this shit. They're doing it out of the back of the van in the fucking ghetto. Same way they're selling drugs. And yeah, you're right. They already have some of the strictest gun laws in the nation. And none of those have stopped their gun crime. They can try to play with numbers all that they want. And see, California is lucky to an extent because much like other places, most of their gun crime is confined to very small areas. However, the gun control is across the entire state. So they can say, hey, look, these gun laws are affecting stuff. No, they're not. The people outside of those very small areas aren't committing gun crimes in the first place. So there's that. And the people inside the areas that where all the gun crime is at, they're committing gun crimes regardless of your laws. Oh yeah, 500, and that bill. It's what, HB 266 or something like that. That's the dumbest. Well, I won't say it's the dumbest one so far. It's the longest bill. I got to do another video. There is a bump stock ban bill that these idiots are pushing, where yes, it talks about bump stocks for just a second, but it also bans anything as far as short-barreled rifles and short-barreled shotguns and FA items that are still federally legal. So if you had all right, we'll check that in a sec. You got to make sure that all the colors you color in the correct amount of squares. Okay. So we'll check that in a sec. I'm still helping my daughter homework stuff. But yeah, even if you had an NFA registered short barrel rifle or short barrel shotgun, if this bill passed, which I don't believe they have any hope of passing, you would be a felon in the state of Alabama for owning that, even though it's federally legal. I think we ought to be going in the other direction, where we tell the feds to get bent and we make more things legal instead of making more things illegal. So there's that. Warsaw, what's up, brother? Oh, yeah, Warsaw, you're 100%, man. That's government, and I've said it before, government is a cancer. This cancer says they can solve your problem if they just give you more cancer. It's like saying, gee, you had pancreatic cancer. You need colon cancer to solve the pancreatic cancer. No, it's still more cancer, but that's the way government is sold to us. So yeah, it's
surround the ones at issue in SB 915 and SB 264 talk about a sale being when a background check is initiated, because when you start a background check, you submit something called a dealer record of sale.
Yes. So if I go in there and check all the tours out
of the sales, so the sale happens before the background check
So there could be a verbal agreement to later on initiate that background check.
Give Daddy a sec.
Process or
I'll
exchange
go
money.
check.
That's not prohibited.
Boards are put up.
I don't know. I don't think that line drawing is like really necessary for this kind of facial challenge here, because I think plaintiff's argument and the central district court's argument is that you read into sales, offer for sale, and negotiations. And our position is that offers for sale and the kind of negotiation.
Warsaw, we're not behind. We're not far behind.
What is prohibited? What must be done is, a vendor can say like, I have this gun for sale, but we need to complete the transaction at my brick and mortar.
I got a goon bean.
I don't think we've ever taken the position that offers for sale are prohibited.
My son was showing me his flashlight.
97.
Okay. I'll give you 3 minutes.
Sure.
Thank you.
Yeah, that's the one thing my son's flashlight has over mine. His has a whistle on it. My goon bean doesn't have a whistle. Goon bean, get to work on that. I need a whistle flashlight.
Good morning, Your Honors. May it please the court. Anna Barver, counsel for B&L Productions Incorporated. Today, this court is asked to decide whether California's ban on speech associated with the sale of firearms, ammunition, and precursor parts, and by extension, gun show events on state property can withstand constitutional scrutiny. The state claims that it can because First Amendment conduct and Second Amendment conduct are not restricted. In fact, the state claims that it has never taken the position that offers for sale are not restricted under the challenged statutes. That is not supported by the record. The trial court found, and it is in fact true, that that counsel for the state conceded during the oral argument hearing that offers for sale are restricted by the challenged statutes. That can be found in the OC excerpts or excerpts record.
I'm listening, but I'll be right back.
I understand the arguments back and forth, but we're now trying to look at the text of the statute. Is there something there?
Do I still have my
the line
backpack?
where you
Yeah,
argue
I got my
it's
backpack.
wrong?
I see
Well,
the
it would
Golden
have to
Explorer
be
song all the time
because
every time we put it on.
otherwise the law wouldn't do anything. As Your Honor recognized, California law, notwithstanding the existence of the challenge statutes, does not allow for the exchange of guns for money at gun shows. That can only happen at least 10 days later after a background check at a brick and mortar FFL store off of the premises of the gun show. That matters because the sale can be stopped at any time in those 10 days, especially if the background check comes back saying that the sale must be stopped. So it's a conditional transaction that is happening at the gun shows, correct? And so the speech, so if the physical transaction, what Nordyke 1997 calls the physical act of exchanging guns for money, can't be happening at gun shows anyway, the challenge statutes wouldn't do anything if it were not to
Lots of statutes that don't actually do anything. I'm not sure that's a constitutional violation.
It's not a constitutional violation, but it's an issue of how the court should interpret this law. It shouldn't interpret this law to principle of statutory construction that the court should not interpret a law to be meaningless, to be adding just superfluous language into the statutes.
Oh, you want us to interpret the law in aggressive fashion that you say is unconstitutional, as distinguished from the doctrine of constitutional avoidance, which tries to avoid constitutional problems. I don't think that's right.
No, the plaintiffs are asking the court to interpret the law the way the state, in fact, conceded the law is to be interpreted in the trial.
Well, I'm reading the law. So I'll go back to the question I posed. What is it in the text of the statute that you find a violation of, First, Second, or any of your constitutional arguments?
On the First Amendment argument, the word sale. The Black's Law Dictionary definition of sale that the trial court looked at includes mutual assent, which requires offer, acceptance, and consideration. So the trial court was right to interpret the definition of sale to include.
Pretty much, and let me stop her right there and I'll answer 500 real fast. Yes, pretty much every single gun law that I have ever read has a carve out for, say, military, law enforcement, all that. They're not going to limit these state actors, but they will limit your rights, which is funny when all of these leftists sign on to this shit. They're so for gun control, and then they talk about the police having all these machine guns and shit like that. Well, they're evil people, yes, but They're the only people you want to be allowed to own guns. Leftist logic. It's just you can't win against that level NPC, man. It's like the boss on a game you just can't fucking beat because no matter what you do, they just pound you into the ground. It's the unkillable, invincible boss. That is the NPC, and unfortunately, those dum-dums vote. And they vote for dumb politicians that then put people like this on the bench, and then we have to deal with these people for decades. And for those of you who don't know, haven't heard me say it yet, Joe Biden has put hundreds of judges on the federal and state or circuit benches.
It was easy.
It was easy.
Mm-hmm.
All right, well, do me a favor. Put this in your folder neatly along with your other sheet. Then go pick the toys up out of the living room, and then we can throw something on the TV. You hear me?
Yeah.
All right. Brief little intermission. Back to the idiocy.
That speech, because if he did not, again, the law wouldn't do anything. And again, the state conceded that offers for sale are restricted under the challenge statutes. In the Second Amendment,
Cool deal, Warsaw.
the Second Amendment is
I'll look at that in a little
implicated because this is a restriction or regulation on
Thank you, brother.
sales of
Sending that to me.
otherwise lawful firearms. California has not banned firearms entirely, but it has restricted sales. And because that conduct, sales of firearms, comes within the plain text of the Second Amendment, it is
Well,
presumptively.
no, stop.
Yes.
Where does the Second Amendment
Hell yeah,
specify
Warsaw.
sales of firearms?
The Second Amendment has repeatedly been held under this court's even pre-Bruin decisions to include not just the right to possess lawful firearms for lawful purposes, but those predicate.
Judge, let me explain something to you, you absolute leftist idiot. To be able to own something, I have to be able to acquire that product. Not everybody can manufacture their product, which in the state of California, you guys have just about stopped through all your other dumbass laws. So therefore, I have to go find somebody that can produce that product, and I have to be able to purchase that product. This is a general basis of firearms ownership. Speech is a little bit different in some ways because I produce speech with my own voice in a lot of cases, or I can produce memes, or I can produce text. So speech is different. Most people can produce speech by themselves. With a product, a mechanical product, I have to be able to acquire that along with ammunition and along with all the other things that make that product work. If I'm writing with normal, say, paper, I have to be able to acquire paper. I have to be able to acquire ink and a pen and all the stuff that will help me put my words down on paper so that I can practice my free speech. You jackass. I'm a welding dude. I basically have the equivalent of 2 associate's degrees. Well, I do have 2 associate's degrees plus. One in gunsmithing, one in welding technology, along with a lot of other classes. And as far as being, educated in biology and things like that, that's a whole nother story. You're a judge. You are supposed to judge laws based on constitutional facts, not your feelings. You're not supposed to measure an inch against your quarter-inch pecker. You're supposed to put things down in concrete terms, much like I've talked about me being a welding inspector. I have a code book that I work out of. That code book defines things in very specific terms. If I don't like something, but it's not covered in that code, guess what I get to do? I get to fuck right on off, and I can't do anything about it. just because you don't like firearms, guess what you get to do? You get to fuck right on off. Agorizer, can't you just have, yeah. It's just it's magically delicious. Yes. In almost any profession these days, we have codes that we have to follow. If it's outside of that code, guess what? It doesn't fall into that particular part of our profession. Just doesn't. Until you work in feelings. You know, I feel like I could go weld on an aircraft. It's not part of what I do. Hell, I feel like I could practice law and could probably do it better than these dickheads, especially when it comes to firearms. But I don't hold that particular endorsement. So guess what I get to do? I get to have a YouTube channel where I drink, smoke, and bitch about shit. That's basically my entire channel. Yes, 500. Absolutely.
Acts necessary to make that, to make it the right required to meaningfully exercise the right.
Let me
That
shift you to
includes-
the San Diego case. Because in the San Diego case, the Second Amendment argument was raised. I think it was the Second Amendment, First Amendment. Anyway, in an amended complaint. It wasn't in the first one. And district judge wasn't happy about that. He grumbled a little bit, but he acceded to it. When he granted the state's motion, he did grant leave to amend with regard to the Second Amendment claim. And I understood that was to permit the client in that case, which I guess is the same client as in this case, B&L, same entity, right? So that's part of the confusion. Permitted an amendment of the complaint to speak specifically to that issue. And you didn't amend the complaint, which said to me, well,
yes,
actually, no, this doesn't really inhibit the ability to obtain the firearms necessary to satisfy the Second Amendment, keep and bear arms. And I haven't seen any evidence that suggests that, in fact, it does seriously inhibit the ability to obtain firearms. Is there evidence to that effect? And if so, why didn't you amend the complaint to make such an allegation?
It just has to infringe.
Because it doesn't matter.
Well, wait, you just told me it matters. You told me that the Second Amendment is limited to keep and bear arms, but that includes, and I get this, the ability to acquire the firearm. But you didn't allege that the latter was required for the former.
Plaintiffs did not allege that there was what did Your Honor call it, a substantial inhibition of the right to acquire firearms, because after Bruin, that type of analysis is improper. That's a severity of the burden analysis that Bruin rejected. What matters is whether or not sales of firearms, that conduct
tears you a new one.
implicates the Second Amendment. And it does. So the burden is on the state to establish, based on history and tradition, that its narrowing reading of the Second Amendment claim, right? That is the ban on sales
Well,
at the
if sale were within the Second Amendment, I might understand that interpretation of Bruin, but it's not. You're the one that's made the link by saying you can't keep and bear without having acquired. And I don't see anything. Point to me to something in Bruin that says an insignificant inhibition on the ability to obtain a firearm is a violation of the Second Amendment.
Bruin doesn't talk about significance or severity. It rejects talk about significance or severity.
Yes, significance and severity of weighing interests. I'm not talking about weighing interests here. I'm talking about if it doesn't have an impact on the ability to keep and bear arms, how does the Second Amendment speak to it?
The Second Amendment speaks to it because it does impact the right
How?
to bear.
You haven't alleged that connection. You were given the opportunity to allege it and you didn't.
Plaintiffs are alleging and have alleged in their First Amendment complaint that the Second Amendment is implicated because it restricts sales which necessarily restrict the ability to acquire firearms.
Where in your complaint, maybe you just point me to the page number, do you allege that there is an infringement upon the right to keep and bear arms? Where is that? What page of the
I
complaint?
can't recall the pages, but it would be the sections, the paragraphs about the Second Amendment restrictions and the claim, the cause of action for the Second Amendment cause of
Let me
action.
ask.
Yeah, but and again, I feel sorry for people in California, but this isn't just California. This shit's coming everywhere. That video today, the assault weapons ban introduced in Alabama that would basically ban any semi-automatic.
Ask this a slightly different way, but I think it kind of gets to the same point, which is, so you'd agree with me that plaintiffs don't have a Second Amendment right to purchase firearms anywhere they want, right?
I would not agree with that, Your Honor.
Cover this.
You would not agree with that. You think the Second Amendment right that you're citing to is that your client has a right to acquire, to purchase firearms anywhere they want.
Couldn't they just got Home Depot
people
and got
have
one?
a right to acquire or purchase firearms wherever they want, as long as the history and tradition does not support a restriction on that place. For instance, selling and buying guns in this courtroom, right? That is as a sensitive place that hasn't been understood since the founding. The government would have the ability, under the historical and traditional analysis of Bruin, to make that restriction. But what we're talking about is whether or not.
Okay, so let me stop you there. So I think you agree with the idea that there can be restrictions on where B&L can purchase firearms, or where a person can purchase firearms or B&L can sell firearms.
Only to the extent that such a restriction is based on history.
I understand what you're saying, but you would agree that there is no Second Amendment right to acquire firearms anywhere at any time. I understand that you have this sort of second piece to it, which is that you're tying to the analysis in Bruin relating to the history and tradition. But the reason I'm asking you this question in this way is because I think what the questions that you're getting from the panel here, and one that I have myself, is that in your complaint, and I think specifically at paragraph 61 of the amended complaint, you allege that two of the plaintiffs are some of the same licensed vendors that have brick and mortar stores in.
Which one, Sam? That assault weapons ban? I don't think that'll go anywhere. I don't think any of this. Well, there's one, two. There's a red flag bill, and there's one about basically pointing towards Glock switches that I think will go somewhere in Alabama. But as far as that assault weapons ban, I think that jibber's dead. But I still think, even though I think it's dead right now, we need to be bitching about it hard to try to tell them don't ever bring that shit back up. Because, I mean, that's where Virginia's at in a lot of cases right now. With VCLD and their lobby days and stuff, where they've talked about these bills, even when they weren't coming up, VCLD was down there. And then all of a sudden, kind of composition of the legislature flips. And now they've got, according to Washington gun law, like 36 unconstitutional gun laws that are going to hit the governor's desks. Most of them are there now, but there's like 36 bills, or maybe more than that he's going to have to deal with. And if I was him, I'd veto every damn one of them and call it a day. But with media pressure and all the other bullshit, then the anti-gun people are going to get some of that, but they won't get all of it. So we'll keep an eye on and see what Youngkin actually signs.
I had a guy come in the shop today and ask, could a convicted felon get a gun? No. No?
If they have been pardoned and they have had their rights restored, yes. If they are just a convicted felon, kind of depends.
Because in the community or operate legally over the internet and are registered with the state as lawful businesses. So you are alleging in your amended complaint that there are mechanisms and places that there's no limitation on the ability to acquire firearms, that there are in fact other
Until he
opportunities
gets
for
a
that
full
to
pardon
occur,
or gets an
correct?
infringement, he's fucked.
No, this is a limitation on the ability to sell and acquire firearms while it is in one space and one can do it elsewhere. That doesn't mean that the conduct at issue here that we're talking about, buying and selling firearms, is not implicated by the Second Amendment and the challenge
So
statutes.
your view, as articulated here, the Second Amendment, is that it, without the historical limitations,
100%, 500.
limitations on sale, purchase or sale of firearms violate the Second Amendment unless you can find a historical antecedent. And that's true in your view, even though the
I'm
Second
listening. I'll
Amendment
be
doesn't
back.
say word either sale or purchase. And the link has been understood to be, you can't have a right to keep and bear unless you can acquire. My question, I guess, and I'm trying to make it clear, is that try it this way. And you're saying we can't consider significance. So let me just pose it in an extreme case. If a single purchase or sale is inhibited because of this statute, you take that to be a violation of the Second Amendment, even though the person involved could acquire the firearm through other means.
No, that's not what we're saying.
Okay,
We're-
so that's
but
why
we're
I'm trying to pin this
What
down.
I'm trying to say is that it implicates conduct presumptively protected by the Second Amendment. So in that case, the court must conduct a historical and traditional analysis. The trial court
Stop me there, because you're saying it's got to be the historical analysis and the significance between the connection. That is, whether the purchase and sale limitation would have an actual impact on the ability to acquire, you're saying is irrelevant. You still have to go back to historical analysis.
the severity of that burden at that step of whether or not conduct is implicated, that's right. It doesn't matter. It may come into play when the court is conducting the historical and traditional analysis, when determining whether the historical analogs that the state puts forward are of similar type and kind and
Well, let me pose the question I was starting with, which was an extreme case. The inhibition of a single purchase or sale cannot be sustained under the Second Amendment unless you can find a historical predecessor.
Correct. If there is no historical predecessor that would be like the challenge statute that is barring that single sale, it can't be upheld.
Then you seem to, in fact, be saying yes to the question you just answered no to, which is that, yes, in your view of the Second Amendment, a single purchase or sale inhibited by this statute, even though the citizen in question could acquire the firearm easily through a different source, is enough to trigger all of the Second Amendment analysis requirements.
That's what I've argued.
Even though the link to keep and bear arms is highly attenuated, if in fact the citizen could acquire that firearm some other way. That's what I can't figure.
Because it's not highly attenuated. The plain terms of the Second Amendment, keep and bear, necessarily includes those predicate acts. This court has held that repeatedly. And
And I've conceded that. I agree with that. The problem is that you're telling me that just because I got to cross the street to get it from over there, that's enough to trigger the Second Amendment protections. And that's what I don't understand.
Oh, yeah, they saw a video of it.
I don't have a better answer for you than that is what Bruin held. That the history and tradition, that analysis has to be taken into consideration.
Once you get into the Second Amendment, my concern is that I haven't seen how you get to keep and bear arms if in fact the arms are readily available and the citizen in question can get them by crossing the street.
Because
So
the
is there any case that speaks?
What the fuck did he just ask? How do you get to the Second Amendment if you can cross the street and go get them? Yes, but I should be able to get them wherever they are sold. Gun shows typically sell guns. I should be able to get them at a gun show. I have to be able to acquire them to be able to keep and bear them. Oh, shit, fire. We need to slap 20,000 volt shock collars on every judge on a panel like this. And every time they say stupid shit that's unconstitutional, just shock the fuck out of them. And maybe after a couple cases, we can break them from being stupid. Yeah, PV. Yeah. It's hypothetical on whether it can occur right across the street because I don't know. There's so many other gun laws in California. Fucking okay.
To this particular problem.
It's probably going to be this case, Your Honor.
So there's not a predecessor we can look
Bruin
to.
is clear that it's about implication. They are presumptively, that conduct, if it's presumptively
The
protected.
keep and bear arms, yes. The sale,
Yes,
okay, maybe this is the case.
I think Bruin explains that though, right? Because Bruin itself did not deal with keeping or bearing. It understood that the language. So Bruin dealt with carry on sales, right? Carry is nowhere in the black and white letters of the Second Amendment, but the court understood that that bear had to necessarily be referencing carrying outside your home, right? And so when that law implicated carrying outside your home, even though it wasn't the black and white letter of the Second Amendment, the historical and traditional analysis attached. That's similar to here. You can't keep and bear arms if you can't get them. So
but you haven't made the case that you can't get them, and you didn't amend your complaint in the Del Mar case to allege that they couldn't get them.
I would be cool with
to allege that you can't get them. What I was trying to say was, if the government is able to start deciding that. If it is not if it doesn't implicate, if a law does not implicate the Second Amendment, just because it's not a super severe burden, the government can start to say, well, you can't buy them here,
say something
you can't buy them here, you can't buy them there, you can't buy them over here, and then you can't get them. At some point, that is clear. So this talk about severity of the burdens doesn't work because Bruin rejected it. History and tradition controls. I do see that I'm well over my time.
Another case,
yeah,
we'll have more time.
Case, so yeah, you'll have another 20 minutes. Thank you.
Okay, now the state gets to come back up and take their second kick.
I'm going to start with the First Amendment points first before going to the Second Amendment. And if I don't get to that, then I'll just address the Second Amendment arguments in the next argument.
Right.
So to the point that we conceded that offers are barred, that's not true. At 2 ER 43 and 44, at that argument, we made clear that dealers and vendors can advertise and make offers for sale. I think the language that counsel might be pointing to is it's the consummation.
Let me throw something in the chat while
that
I'm
was
thinking
made
about
in
it.
the argument. But I think at 2 ER 43 and 44, we made clear, as well as in all of our briefing, that offers for sale are not prohibited. To the point about a sale not being done until after the physical transfer of the gun happens, Nordeg 1997 was aware of the waiting period laws for firearms. It cited the waiting period law, which at that time was Penal Code Section 12071. It cited it in footnote 2. And it still said that the sale happens when it's the act of exchanging money for a gun. So I think that kind of rejects their argument that a sale doesn't happen until you have the physical transfer of the gun. Because when you do a dealer record of sale and the background check starts, the dealer record of sale is for a specific firearm. It's for the serial number of that firearm. So that gun is essentially that person's gun so long as they pass the background check.
Let me throw this out. I guess Dark and Rich and Crump are kind of doing a dual stream tonight at 9 for Bella's Wish. Fundraising for Bella's Wish. So you guys check that out too after we're done with this. I just want to make sure I posted that.
Check. And also for ammo or ammunition purchases, there is no waiting period. And so you can go to a gun show.
That's just one. Dark will have a stream where there'll be multi-stream.
You can go to a
Dark
gun
will
show,
be there, Flying Rich,
buy ammunition, and walk out with ammunition at the same time. And so we need a definition of sale that is consistent across these types of purchases. Unless the court has more questions about the First Amendment, I'm going to move to the Second Amendment.
You can move on. Thank you.
think as this court mentioned, the plaintiffs do not point to allegations either in the Central District case or the Southern District case that shows that these laws in any way impede their right to purchase firearms. And I think that is simply holding them to their Twombly-Iqbal pleading standard. And
okay, some of these gun shows we're talking about are some of the, I guess, the largest gun shows in California, where many people go to purchase firearms. Now, they still, even on a person-to-person transfer, have to go to an FFL, go through a background check, go through a waiting period to receive the firearm. So pretty much nobody is legally going to a gun show, paying cash, and getting a gun right then. The state shouldn't even have an argument here. They're already getting away with fucking murder. But their point is if they can't sell guns at these gun shows, then it's not hurting anybody. It's not, it's not infringing on anybody's rights, which they won't use the word infringe. They'll talk about burden and all this other horse shit. But yes, it is an infringement. That's all it has to be. If you tell me I have to walk through 3 locked doors to get to the gun show, that's an infringement. You douchebag. But this is the Ninth Circuit.
And that is what this court did in the Imbach decision in Teixeira. And Teixeira is still is not in tension with Bruin because there was no interest balancing that was done in Teixeira. What Teixeira said is that for the asserted right of sellers to sell firearms, looking at the Second Amendment's plain text as informed by its history, that there is no independent right to sell firearms under the Second Amendment. And then, so that withstands Bruin because Bruin also tells us to look at the text and history. There was no interest balancing done for that. There was no comparing of the burden against government interest.
This dude has
and the same can be said for
so
the argument about purchasers. But I see I'm out of time. But if I can just finish that thought really fast. For purchasers, it was just what the court was saying is that if you can't even allege that your right is at all impeded, you have to be held to the plausibility standard, just like any plaintiff must be held. The fact that you're alleging a Second Amendment complaint doesn't
someone make a
it's not a safe harbor from Twombly-Iqbal, and that survives Bruin as well.
All right. Thank you very much.
Thank you.
Thank both counsel for their arguments. This case is submitted. Next case is B&L Productions versus Newsom. You can just come back where you are. Yeah. See you again soon. Please just stay where you are, and counsel, you can come up when you're ready. Thank you.
You made a redhead joke.
I did.
Did it involve nuclear weapons, mushroom clouds?
No. I have to fabricate a cocking lever for a burial shotgun.
And we haven't forgotten everything you said.
Yeah, so exactly. But please reintroduce yourself. Let me know whether you want to reserve any time for rebuttal. But we do have your arguments from the first case. So.
Thank you for clarifying that. I will. May it please the court. Again, Anna Barver for B&L Productions et al. I would like to try and reserve 2 minutes if I may.
I'm a fucking ginger. I got none of that shit.
In 2019,
I could give you a
2 years before the events that gave rise to the challenge in the
But if Goon was in here, I'd seriously start making
California
some jokes.
banned the sale of all firearms
You still haven't told him?
It later added firearm Patricia parts at the Del Mar Fairgrounds only in San Diego. While the law there did not expressly ban gun show events, banning these events and the speech that takes place there.
Although I do have them saved up and ready to go.
The question presented here is similarly to the the Orange County.
No, I don't have the edited proof.
Whether California's eradication of this long-standing avenue
If I could save up all of my humor and write this shit down, I could do stand-up for a living. Huh?
The answer is no, under both the First and Second Amendments. But this case is even simpler than that. This case is before this court on a dismissal of B&L's claims on a Rule 12 motion to dismiss, and only after the court assumed facts that were not evidence, including the argument that offers were not part of AB 893, disregarding the well-pled facts of B&L's first amended complaint, that they in fact had been restricted and barred from getting gun show events on the calendar. And finally, in the case of the Second Amendment, failing to conduct any historical analysis,
I'm getting that holster off with one hand.
This court should reverse.
One car.
I
What's
want
up?
to first, I think, talk a little bit about why speech is in fact addressed and covered by AB
Yeah,
893.
one car. Property taxes, all right here.
The record in the trial court in Orange County, you would see this was a substantial question. It took up a lot of time during the parties' oral presentation for the court. It was its first and most obvious example of speech being restricted, of course, is that the fairground staff did in fact refuse to contract with B&L to host or calendar gun shows at both Del Mar Fairgrounds and the OC Fair and Event Center since the laws took effect. The state talks about,
especially since we already kind of heard this part before, and I'm going to say something. Public service announcement. If you don't own an Instapot, you need to own one. And if you have to do rice, Instapots have a setting for that, and it is absolutely amazing. So that's my public service announcement for the night. Oh yeah, my wife's screaming from the bathroom. I'd like to preface that with, you do know how to make rice. Yes, I can make rice in about anything. However, the Instapot is the fucking bee's knees. Just want to let everybody know.
Talking about gun shows without the sale of guns. So you're talking about the interpretation of the district of these laws in a way that would bar the scheduling of all gun shows, even if there was a limit on the sale and purchase of guns.
Yes, Your Honor. There not only was it in the allegations of the first amended complaint in Del Mar, it was the allegations of the complaint in Orange County, but there is a declaration from Tracy Olcott, who is B&L who works for B&L Productions. She is the conduit between OC Fair Events and the Del Mar Fairgrounds and Crossroads.
So are you seeking relief? I asked.
Hold on, that is cold.
It is not.
My wife said me advertising for Instapot rice without first letting you guys know that I know how to cook rice without an Instapot is a basic white bitch thing.
I'm just saying.
I'm not saying she's wrong. I'm just saying it's hitting below the belt.
But you advertised that you knew how to make rice,
though. Oof. Barton, I have not tried refried beans in it. I got it. Well, you...
Whoever said that. I hope you spill your coffee tomorrow morning.
Oh, God, yeah. Barton, my wife, just absolutely insulted you. She said she hopes you spill your coffee tomorrow.
Which one? Mommy. It's Baba. Refried beans is disgusting.
You leave refried beans alone.
No, that is disgusting.
Look, just because you don't have taste buds doesn't mean the rest of us don't.
No, that's just it smells gross. It looks gross. It tastes gross. It's what I imagine if you didn't have a circumcised
You eat
penis.
olives in.
Hey, let me finish. Did the middle of my sentence interrupt the beginning of yours?
No, because the beginning of mine is all that mattered. I'm gonna get shot. If you hear a boom, a flash, and I fall over, I just got shot on stream. You guys got the evidence. Don't let that shit get deleted.
I don't know. They heard what you said.
I know, but they can't see what you're doing. Yeah, you guys might see a murder on screen.
Your opposing counsel in the first argument, this question, but I didn't have an opportunity to ask you. Assuming that we reject your facial challenge, is your view that you would be satisfied with an order enjoining the law as interpreted by the district to bar gun shows where there are no sale of guns? Because the way I read your complaint is that there's no financial incentive to have these gun shows if there isn't, people don't come and businesses don't want to be there, vendors don't come if they can't sell guns. So I just, I don't see anything in your complaint in which you seek relief specifically as to an as-applied challenge.
No, B&L, none of the appellants would be satisfied with an as-applied construction that would allow they're going to call them gun shows that don't allow gun sales. That's not,
Okay, so
That's not a thing.
So the
Gun shows
allegations
allow gun sales.
So the allegations you're making and the relief that you're seeking is really for the whole shebang, not
Correct.
for the gun shows
Correct.
without the sale of guns.
Yeah, gun shows without.
Let's throw another analogy out here real fast, just because it hit me. You can't have strip clubs unless women actually strip, and there is a way to pay them for stripping. If I go to a strip club and they're all wearing parkas and mittens, and I can't see anything and I can't tip them, then it's not a strip club. It is a parka show. So if you advertise something as a strip club, and I haven't been to one in shit fire, damn near 2 decades.
Hey, Pat talked about going to strip club.
Yeah, I haven't been to one in at least 18 years. But when you go to a strip club, women, you guys want to see guys dressed down. Us guys, we want to see merchandise and want to be able to tip. And if you advertise something as a strip club, and again, all you see is parkas and mittens and balaclavas, that's not a strip club.
My mom just texted me, Ireland sounds nice, which is code for she's mad at my dad.
Oh, well, if I got to pick him up tonight, I'll pick him up. But
No.
Out the sale of guns are not a thing. That is an event, an entirely different event. That is not the business model of our client. That is maybe an educational event about, guns. It's not a gun show. Gun shows involve commerce in arms.
So we went through this when I was trying to pin down the state's position.
She said, giddy up.
And it appears not to be contested.
love your mom. I got to be one of the more people I know.
Waiting period,
my
so there
mother-in-law.
wouldn't actually be delivery
I
of
would do anything with
firearms
my mother-in-law.
at the fairground.
Correct.
What is your understanding as to what the state won't permit that makes the statute objectionable?
It would have.
If we understand that the state
It's objectable.
has taken the position that the offer for sale can be made, the parties can talk about it, and either way, the gun doesn't get delivered until after the waiting period at some other location. I'm having trouble figuring out just what the difference is here.
This assumes, again, that the state is telling you the truth about what it believes the law does.
Well, see, if we're taking this as a facial challenge and we say, this is what the state says it is, this is what it is, what's wrong with that from your perspective?
Can I read you the record?
Well, see, I'm not so much concerned because this is a facial challenge. And parties, I see lots of cases where parties' positions evolve over time. We're concerned about what is it we're supposed to do with the challenge. And the facial challenge is now articulated in such a way, I'm having trouble figuring out not what position the state might have taken. I know the state's going to say it didn't take that position. I don't really care very much. I'm concerned about a facial challenge now, and if the state has conceded that it will permit the offers for sale, where's the problem?
I'm just saying.
The state hasn't conceded that. It has rejected that position.
I'm not saying I ain't
Well, I was sitting here in the last argument, and you were too. We heard what the state deputy attorney general said. What in the line that he sought to draw is problematic from your perspective?
If all the speech is allowed, if they're allowed to advertise, they're allowed to offer, they're allowed to accept the offer, negotiate terms, I mean, then I guess
the one piece I may have to go back and pin down, I was focused on the offer side and the negotiate side. And it was explained, but I didn't pick it up quite so much, that the background check is triggered with the entry of the agreement. So maybe I need to work on that with the state, and he has now a warning that we're going to get there. Let's take that either way. If the state's position is you can offer, you can talk about, you can have your display,
I'm not
you
picking
can't deliver, that's not contested, and you can't sign the credit card slip that triggers the background check. That may be a bone of contention. I get that. Is that the only bone of contention at this point? If in fact the state will allow
guys do care
the
about
display, the offer,
They just laugh at me
discussion.
like I'm the dancing.
If that is what the state is allowing, that's what it's always allowed. And so gun shows can take place. I don't know then why the OC Fair and Event Center and the Del Mar Fairgrounds refused to contract with my client to have gun shows, even when they agreed that they wouldn't do any kinds of sales transactions. That would probably be something you have to determine in the trial court with evidence. That didn't, that couldn't happen in the Del Mar case because it was on motion to dismiss.
Why does it matter anymore? If in fact this is a facial challenge and we ascertain either there's no difference between the parties or a thin difference that we may have to adjudicate, I'm trying to figure out what's there for the facial challenge today.
Again, if the state's position now is that all of that speech can happen and all of those transactions can happen, then this is back to where we were before the laws were passed. And I guess Del Mar would be having gun shows again, and we'd be happy with that.
Your papers have taken the position that without the actual sales, these things are economically not feasible. I don't know that that's a position you're going to continue maintaining today, but I read that someplace in the materials. And so I'm not trying to say that the parties haven't gone back and forth and altered positions and recognized events. I'm trying to figure out what do we have that the difference is today. So to tell me that, well, that we offered that and they didn't do that. And so that's past history where both sides can say, that's not what we heard. That's not what they were willing to do. I'm trying to figure out for a facial challenge today.
This guy knows exactly.
Is there any difference other than this potential difference with regard to signing the credit card slip?
I think I've answered that. No, that if the state is being honest and the court interprets this law to mean sales
500
doesn't include what the dictionary definition of sales means, which is the speech including offer and acceptance, which the trial court in Orange County found that it did, then I guess B&L would be having gun shows again, and they'd be happy with that. But there is a reason that gun shows were banned. The sponsor of the bill repeatedly has said that this is a ban on gun shows, all events. The sponsor of the Orange County bill sent a letter directly to the district association board members.
If the state, and this is joined to this, so if the state thinks that a background check is such this important thing that stops these criminals, to me that would be kind of a law enforcement function. So make the NICS background check accessible to your average citizen. I type in my name, I do whatever. I type in the buyer's name and social security number, and I send it through. State takes care of all those functions, takes care of all the cost. To where if I'm doing a person-to-person transfer, that's the cost is on the state. That's a law enforcement function. It just, why isn't, if the state's so worried about, even if I fund it, even if I pay $10 for a transfer, if the government is so worried about prohibited possessors from getting firearms, and they say everybody has to do background checks from now on, why is it not accessible to me as a seller who is going to sell a firearm, a person-to-person transfer? Why is the NICS system not accessible to me? If it's about stolen firearms and stuff like that, why aren't all the reported serial numbers on firearms sent into a database where if I go to buy a firearm, I can search that database real fast with a serial number and go, oh shit, wait a second, that person's trying to sell me a stolen gun. Well, here's the truth, kids. None of this is about public safety. None of this is about stopping crimes. This is all about control. And the government, the state, and the people who believe in the government and state powers don't give a rat's ass about crime. All they care about is using a narrative to push more gun control. That's all they care about. And it's the only thing they care about. And these statist judges, like these pricks on this panel right now, they don't care about your rights. They don't care about constitutions or anything like that. All they care about is upholding the state's power over the individual. I really love for someone to try to argue with me differently on that. And I'm really easy to get a hold of if someone would like to argue that point with me. Because we can go into the numbers, gun crimes, homicides, actual murders. We can dig down through all of those. And yes, you're right, 500. There is no such thing as a free state anymore. Period. We've been done since probably right before the Civil War. Our goose was cooked before then, but definitely after then, our goose was well done. It just char-broiled at that point. And Bart, no, they'll never second guess background checks, man. Because let's remember, background checks, the vast majority of people they stop are all similar names and stuff like that. That's the reason you don't see a whole lot of people prosecuted for lying and buying, because the vast majority of people who are actually denied on background checks aren't actually prohibited possessors.
Members saying, I will sue you personally if you agree to contracts for gun shows because we banned them. So I have a hard time believing that the court, that the states now concession.
Let's focus on what may be the area of contention. And we'll certainly hear from the state.
Another
evening,
definitely.
After that.
Not tonight.
I do understand.
Not to be here for another 6
said,
hours.
I thought pretty clearly that the first part.
Come on, we're going to be here for
the offer part. That's going to be okay.
I have a good time talking.
Suppose they object, and we've been working to try to identify, is it the acceptance and the signing of the credit card slip or the payment of the cash? I guess some people still
I'll
use
be on
cash.
there with Bishop again.
I was at a hotel the other day where you couldn't use cash. Go figure. But I'm old enough, so I still carry cash. What can I say? Let's focus on that. Let's assume we do have actual disagreement, a contention about that. What is the basis for your contention that that's a facial violation of the First Amendment, Second Amendment, equal protection?
Well, I'll hit you up. If you don't hit me up first, I'll hit you up.
What's your case?
I can't assume that the state is going to now come back and say that acceptance is no longer covered by the law. But again, in the Orange County Court, when asked by the court, so you're saying there are multiple elements to a transaction, offer and acceptance are a couple of them, and those two, for example, are prohibited at the gun show by these statutes? Counsel for the state. That's right. So the position was that both offer and acceptance were barred by the statutes. If now the position—
Actually, I hear that as saying both, not necessarily either separately. So let's focus on the acceptance. Mm-hmm. That appears to be the potential disagreement. Why is it acceptance at the gun show is protected by the First or Second Amendment?
Because acceptance of an offer is commercial speech. It is speech that does no more than propose and engage in a commercial transaction. So you have.
All right, let me pause here for just a second. I'm going to throw this out here. This is Bishop on Air. Now he covers a lot of things around Illinois, but he does cover a lot of stuff nationally. Typically does a show in the mornings every weekday, starting out at about 8:35 if he starts early, to about just about 9 o'clock if he runs a little long. And that's the show that me and Warsaw were just talking about. So if you're not following Greg Bishop, go follow Bishop on Air. He's a great and he's very professional about what he does. He's nowhere near like me where I smoke, cuss, drink, and do all my stuff. But follow Bishop. He's a really good dude. He's got a really solid show, and he'll keep you up on stuff happening, either going to the Supreme Court or the general stuff in Illinois, and he doesn't branch out as much as some other shows do, but he's a damn good resource. He's really good to listen to in the morning if you want the news on what's happening with the Second Amendment and stuff like that. So yeah, follow Bishop on air. Let me throw. I'm pretty sure I still got it up, or do I? Damn it, maybe I don't have it up. Hold on, I'm gonna throw another link out. Because I was listening to these guys earlier, and I try to listen to them anytime. They typically come on right about 6 o'clock. And this is the Armed Attorneys. And if you're not listening to them, they do cover stuff. They're based out of Texas, but they cover stuff nationally. And, of course, Four Boxes Diner and a bunch of other people. But these cats, Armed Attorneys, are typically dead ass on point with the stuff they cover. And all of us tend to be kind of Second Amendment junkies. So here's another fix you can get. John Crump and them will normally go when they have an evening show, they'll go from 5 to about 6, maybe a little after, but by the time they hit about 6, they're trailing a little bit. Armed attorneys, gotta learn to talk one day. Typically come on about 6, stay on till about 6:15, maybe 6:12. And they're a really good watch too.
What's that curriculars?
So that's just another resource to keep us up on stuff.
Have to do the Central Hudson test.
I've seen commercial speech discussed a lot in terms of offers. I don't know that I've seen commercial speech discussed in terms of acceptance. That's not making a commercial offer to the world that buy our detergent or whatever else. Let's do a contract. Is there authority that says making a contract is commercial speech?
I have no idea.
Contracting is a speech. It is speech. And it is speech that has to deal with commercial activities. I don't know how in the real world, the way people interact, conversations go back and forth. So whether it's the offer or it's the acceptance, all of that is a commercial speech discussion. I don't know how you can peel the layers back between the two. They're kind of necessarily intertwined with regard to this.
One is speech and one is a transaction. Those are different things. Now they can overlap, but I don't have any trouble saying, okay, making an offer, that's traditionally what commercial speech is talking about. Accepting an offer, I don't know. I haven't heard commercial speech discussed in those terms. Can you point me to something where it is discussed in those terms?
At this point, because the conversation has always been that both offer and acceptance were part of this law. And so focusing on whether or not you're peeling the two apart and saying one is commercial speech and the other isn't, I am not prepared at this moment to answer that question, Your Honor. But
yes, 500.
Assuming that it is, we need to move to the Central Hudson test. And under Central Hudson, commercial speech is entitled to full First Amendment protection as long as it is not misleading and it concerns lawful activity. That sort of speech must have regulations on that sort of speech, of course, must have a substantial government interest that is materially and directly served that interest, and it is not more, it is not more broad than necessary to serve that interest.
I think the premise of this argument is that the acceptance part is part of the commercial speech. So we still have the first issue that we've walked around. I just want to make sure I understand that there's not a separate argument.
OB's on.
No, there isn't a separate argument. This is speech, as the trial court in Orange County found when it interpreted the law based on the record before it, the concessions that the state made. I mean, these are things that was where evidence was taken, questions were asked, and the state was put to its burden. In this Del Mar case, on a motion to dismiss, the court took the state say-so in an opposition brief without anything more as saying, this is just speech, the exchange of guns for money, offers not included. When at a motion to dismiss,
Damn
that's
right.
the opposite of the standard that it was supposed to withhold.
Matt and Justin,
Well,
either
motion
one
to
of those
dismiss,
guys should be locked
that's
up.
where you challenge the law. The facts are left open, but I don't hear factual contentions or factual allegations in your complaint that were not
He lost
taken by the
guns
court.
and
Indeed,
probably his gun
on the
right.
issue we talked about before with regard to the impact or the connection between acquisition and keep and bear,
I need to do a story about
specifically,
Vickers.
you were given leave to amend your complaint and elected not to
Machine
do it.
guns.
So where is it that the district court in San Diego assumed facts, made factual conclusions as distinguished from legal conclusions?
In a few places. First, accepting as fact that sales are not speech and sales are not included under
Wait,
AB.
stop right there. That sounds like a legal doctrine. Is commercial speech going to encompass sales, offer, and acceptance, or what? I mean, that's not fact.
The court made a factual finding based on what the state said, that offers are not included by the law, under the law. That is a factual finding. It also made a factual finding that
the conclusion that commercial speech does or does not cover sale is a factual rather than a legal proposition.
when the state makes a factual allegation that it is, it's an interpretation.
How's that a factual allegation? It's a legal doctrine. Commercial sales do or do not extend, or commercial speech does or does not extend to offer and acceptance. That's a legal proposition. Where's the factual allegation there?
There's another factual allegation. The factual allegations throughout the complaint were that all gun shows, with or without these speech, had been shut down, but they.
You know what you call 1,000 leftist judges at the bottom of the ocean? A good start. These people do not respect constitutions, state or federal. They don't respect individual rights. They will always uphold the state's power. And judges are supposed to be advocates. Judges are supposed to be the ones who are kind of a check on state power. Okay, the state, you made this argument. That argument's not really good. You can go get fucked. The right of the people is how judges are supposed to work. That's why we have the judiciary branch of the federal government. They're supposed to be that check, that balance. These guys are rubber fucking stamps with big red shoes on and big rubber fucking noses. And should never be allowed to sit on a bench. It shouldn't be allowed to be a dog catcher. Yeah, dude. There are plenty of people, and it got mentioned during the 34 NFA hearings that, yeah, there are times where someone would have an accident with a shotgun, get it plugged with dirt, shoot the shotgun, it would mess the barrel up, and the person didn't have enough money to go buy another barrel for their shotgun, so they chopped the barrel off short. That has happened. These people didn't have the money to go buy all these other guns or replace barrels and shit like that, so they merely chopped it off back to where it was functional again, and then they kept their shotgun. That could, yes, send them to jail for 10 years at this point. I think the original was 5, now it's 10 for a sawed-off shotgun, a shotgun barrel less than 18 inches. Yes, this dude would completely send your ass to jail for a shotgun barrel that was 17.5 inches or 17.75 inches. I guarantee you, if you got down to 16ths or 30 seconds, this motherfucker would send you to jail. Prison. I'm sorry, not jail. Prison. Prison is different.
That BNL could not contract, so both pure and commercial speech were being restricted. The court found as a fact that plaintiffs had not said that, had not alleged that, had not proven that, but it is in the First Amendment complaint. It's also in the declaration of Tracy Olcott in the Orange County case. That is a factual finding that the court was not free to make on a motion to dismiss.
wanted to save 2 minutes for rebuttal. Do you
I
want to do
then
that?
I would like to do that. At this
Okay,
time.
all right, great, thank you.
I'll be right back.
Good morning again, Your Honors. For formality purposes, may it please the court, Charlie Sorosi for the state appellees in this case. A couple points. So I think for the Southern District case and for the Central District case, the rulings are subject to de novo review because it's applying constitutional principles to facts. So I think both cases are under de novo review as opposed to, at least in the preliminary injunction Central District case, clearly erroneous. There was a lot of discussion back and forth about whether to trust the state's position, but I think I just want to refocus everyone's attention on the plain language of the statute, which again only bars sales. The legislature knows how to use sales versus offers for sale, and that is also clear from the Nordag 1997 case, which again barred sales, offer for sales, and any act initiating a transaction to be completed at a later date. None of these laws bar offers for sale in their plain language. So whether you take my word for it or not, the plain language is what controls here. And so the whole argument about what the state said or didn't say before is irrelevant because the plain
this is
language
about where we
bars,
started this at.
sales.
Well,
And
make sure I understand that. And we do have something to focus on. I never really thought this
And
complaint.
he wants a new
case
review,
would
a
go
de
away.
novo
But
review.
there
of
is a
this because
difference,
he
as I
knows if they
understand
use
it, between
prior
the
reviews,
position
he
of
loses
B&L and the
every time.
position of the state with regard to the acceptance part of the sale. You're telling us that the state's position is that offers to sale are not precluded by the statute, and that at least now that it's all been put on the table and we've written up in some form in our disposition, the state will take the position that shows can proceed that include the offer to sale portion. The objection appears to be on the acceptance, what I was referring to as signing a credit card slip or paying the cash for the merchandise. That's something which the state takes the position is not permitted under the statute. Is that correct?
what we see at gun shows is that payments for firearms and ammunition, which I think we need to look at together, even though we need to make sure the definition is consistent across both, right? Because firearms have a waiting period and ammunition does not. And so I think the question that is ultimately getting at is what is the work that these statutes are doing? And for ammunition, it is because it's barring sales, it is also barring people from walking away from a gun show on state property.
I'm not an expert. I've been
For the purposes of firearms, it's barring the payment for that specific firearm. And to the extent the question is about oral acceptance or a written acceptance, I think that is something that is more reserved for an as applied challenge. But I think
are we talking aerial, the whole thing, or are we just
something
talking protrusion of the nipple
contract? I think that is something that these laws would prohibit.
That's because me and your mom think alike.
Plaintiff's primary argument is, and what
could get us in a
District
ton
Court
of trouble,
held, is that anytime you see a restriction on sales, you see a restriction on offers and negotiations. And that can't be true because that would subject numerous other types of sale restrictions immediately to Central Hudson.
Yours are more like pencil races.
So it looks like I'm running through this to make sure I understand it properly. We have potentially two areas of dispute. One, which I confess,
Unnecessarily.
really focused on and you brought to my attention, is the ammunition. Because there's not a waiting period.
If your areolas look like a plunger and your nipples look like you hacked off the stick on the plunger, they might be a little large.
Just talk to her.
Consummating the sale when there's not a waiting period that's going to require waiting anyway is problematic. We have potentially a dispute with regard to the inability to conclude a purchase of ammunition. And we have a disagreement as to whether the acceptance part, the signing the credit card slip,
They didn't change that. No.
which, as I understand, the state's position is that is precluded by the
What's up,
statute.
Gizzard?
So
Whether that is acceptable under their constitutional challenges.
Conversations I get myself
Let me
into.
start with, do you understand those two items to be potential disputes between the parties? And it will be followed up with, is there something else that we should be mindful of?
Yes. Welcome to Coop's Random
I think
Conversation.
that's right, Your Honor. But I think the dispute about what is an acceptance that is permissible and what is not is something reserved for an as-applied challenge, because what the Central District Court here held,
I
and what
guess
plaintiffs
I gotta throw out the
primary
random,
argument is that it
old
is offers for
rule
sale. That is the
just to
commercial
get people
speech,
in
and
the
that
room.
is what is
Not like
prohibited in
I'm sitting
Central
here.
Hudson, and it is
Never
their
mind.
position that
I
these
won't
laws
go there.
bar offers.
Not even on my
The
own
plain
stream.
language says otherwise, and we've taken the position otherwise as well. And I think Nordyke 2003 is also instructive when it says that it's really interference with speech that makes something a speech restriction. A restriction on non-speech conduct.
I did put the
here
case
sales,
name in the title,
which
so you can't completely
further
blame
down the
me
line
for it.
then hinders profits. That can't make something a speech restriction. You're restricting non-speech conduct that then hinders other non-speech conduct. And the whole argument about the gun show business model, I think there aren't sufficient allegations to even make that plausible, whether it's the allegations in the Southern District case or even the declaration of Tracy Olcott.
He ain't been tied in for a long time.
Their argument is that if vendors cannot complete sales, then they can't cover their costs, and then they won't show up to gun shows. But from a business perspective, that doesn't really make a lot of sense, because why would a vendor would chomp at the bit to get the opportunity to display their products to the hundreds or thousands of people that come to a gun show. And again, while it is prohibiting sales on state property or the fairgrounds, what that actually cashes out to is that these are prohibiting sales at temporary marketplaces that happen a couple weekends a year. These are not brick and mortar locations on the fairgrounds. Rather, what's in the record in the Central District case is that there are over 1,800 dealers and ammunition vendors statewide. There are over 160 dealers and vendors in Orange County alone. And within the same zip code as the Orange County Fairgrounds, there are 6 dealers. That also mentions the number of dealers and vendors in San Diego, which is 90. And we do know that gun shows do occur on private properties in addition to the fairgrounds before these laws. And plaintiffs didn't directly mention this, but to the extent they argue that the sale.
Okay, so again, let me explain this to the short bus crowd. State-owned property is actually property owned by the people of said state. If the property is owned by people of said state, as long as it is a constitutionally protected activity, then it should be able to go on that public property. It is public property. It's not private property. If I own 3,000 acres of ground and I say nothing can go on here but what I say, well, it's my property. It's private property. If the state owns 3,000 acres, there's a lot of hoops they have to go through to prevent me from doing things that are constitutionally protected, state and federal, going on that publicly owned property. Okay, you can tell me I have to have a permit to speak on that property at certain events, because those certain events are going to involve a whole lot of people, and I kind of got to account for security and certain other things during those events. Okay. I don't completely agree with that, but I can see a point there. You can't stop me from speaking on public property. I can get on a public sidewalk and I can scream at the top of my lungs, I don't know, left-handed lesbian Eskimo albino. I should be able to do that. I'm on public property, and if someone doesn't like that, hey, guess what? Go to your own property and you can scream whatever the fuck you want. If I want to get a permit to do a constitutionally protected activity on public property, then the government should have to fucking deal with that. Even if you don't like the activity, deal with it. It is on public property. If I want to have the most stupid ass damn parade down Main Street and say the dumbest shit, guess what? It's public property. I can get a permit. I can do that. There are certain things about decency and other things that, I don't believe you should be able to do it in your lingerie with your butt plug and swinging around your dildo in front of a bunch of kids underage. I don't believe that. Just because they're underage and you can't expose them to that kind of content in any other form, so you shouldn't be able to expose it to them there. But we're talking about constitutionally protected activities on public property. The government may be able to control some of that with a permit, but they can't outlaw it outright, which is what this fucking thing does. So any judge interested in constitutional rights and interested in limited government and interested in the freedom of the people should have told the state to fuck off at this point. Get out of my courtroom, you absolute loser. However, we have judges sitting up here trying to turn themselves inside out to where they can stick their head up their ass, turn themselves inside out. They're a giant walking colon at that point to make this argument make sense.
Sale of an item is inextricably
Let's see people drive off street. They're like,
speech.
Can't stay for that.
This court and the Supreme Court have made clear that the sale of an item can be easily separated from speech. And Hunt in this court tells us that marketing a product and linking it to a current public debate doesn't automatically make that commercial speech non-commercial speech. And so I don't think we get to Central Hudson at all because there's no restriction on speech. But for the reasons in our briefing, we do, if we were to get to Central Hudson, I think we satisfy our burden there. And I think Retail Digital Network is this court's en banc opinion in Retail Digital Network is helpful there to show that for the directly advancing prong, when in an existing regulatory scheme, when you have regulated actors that are sidestepping the regulatory scheme, if the government takes the next step of flatly prohibiting that activity, that still directly advances the government interest. And for the purposes of the fit prong, the least restrictive fit is not what is required. And even if
someone can
careful
simply sidestep your regulatory scheme,
another option,
then your regulatory
Retail
scheme
Digital Network
sucks.
and its affirmance of Act Media said
Pass another regulatory
is an option,
scheme
that doesn't mean
to
something
capture
is
that conduct.
therefore overextensive. I'd like to get to the Second Amendment, to be sure I don't run out of time on that, unless the court has other questions about the First Amendment. The only other thing I'll say about the First Amendment is that in the Central District case, the last time I think BNL contacted the district about a gun show was in December 2021, and that's at 2ER 201. So I'll move on to the Second Amendment. To get back to my points about Teixeira. Teixeira tells us that the Second Amendment doesn't guarantee a particular retail experience, and that is exactly what the Central District Court found when it said that the plain text of the Second Amendment guarantees a right to attend not just a gun show, but plaintiffs' specific gun shows. And that is certainly not what the plain text of the Second Amendment provides. And while the proposed conduct or course of conduct needs to be specifically defined, and we think here it is to purchase guns and ammunition on state property or at fairgrounds, that acquisition right, whatever the scope of it is, does not include the right to buy firearms and ammunition at a particular location during a temporary marketplace like a gun show. And I think Teixeira rejected the similar argument and said that plaintiffs failed to even meet their plausibility pleading standard when making an argument that that because they didn't have a gun show in a particular, or they didn't have, a brick and mortar location in the exact location they wanted, that meant their Second Amendment right was impeded at all. And so I think the reasoning in Teixeira is equally applicable here. Plaintiffs still have not pointed to any allegations showing that any of the individuals that want to buy guns or ammunition have in any way been impeded from buying the firearms and ammunition that they want by these laws.
Well, P&L argues that Bruin sets that aside by saying that you can't evaluate the degree of inhibition or inability to
No, you can't.
acquire.
All it has to be is an infringement.
Acquisition
Period.
is a built-in part of keep and bear arms. So the question becomes, are we allowed to consider the level of inhibition on the ability to acquire? And by citing Teixeira, it sounds to me like you're taking the position that Bruin does not undo what Teixeira says, which would say, gee, you can buy it. I mean, Teixeira said there's another store 600 feet away, so you're not really inhibited. Are we allowed to consider that factor in the wake of Bruin?
The short answer is yes. I don't think there's tension between Teixeira and Bruin because Teixeira didn't do interest balancing, and we're not really evaluating the burden.
This guy would think that any gun ban
here in this
was
first
not
step.
valid Bruin.
The plaintiffs aren't saying, they're saying their second, I mean, they are not asserting any allegations that their Second Amendment right is at all impeded. So I think this is a pretty straightforward case. They're not saying there's a certain severity of the burden, that there are some guns they can get, some guns they can't because of these laws. They're not making any of those allegations.
I think that what her argument is on the other side is that that's not required.
So
that once the Second Amendment,
as much as I agree with you, 500, I will disagree with you to a point. I believe you should be able to say whatever you want, as long as you don't physically try to wrongfully deprive someone of life, liberty, or property. You don't try to just beat that person up. They don't have the right to use force against you. So it's a kind of a force continuum in a way. It's the reason that the ACLU has defended the KKK doing marches through predominantly Jewish neighborhoods, screaming all their racist shit in the past, and the ACLU went to bat for them because they had the right to freedom of speech. It's fine. Now, I'm kind of on that end of things. As long as I don't use force against you, you don't get used force against me. I've went back to the principles that I've talked about before. As long as I don't use, or as long as I don't deprive you, wrongfully deprive you of life, liberty, or property, then the government shouldn't even be involved in it. Shouldn't. Same way I tell my daughter all the time. Someone can call you all the names they want. Someone can call your mom and dad all the names they want. Your nanas, your granddads, your ancestors. I don't care. If they put their hands on you, that's different. If they put their hands on you, you have every right to fight back.
Tell what she said.
Oh, that's when I told them on stream not too long back. That's when she had gotten in the principal's office and finally got to the root of things. And she said he hit me and I hit him a lot. And I was like, okay, as long as you didn't start it, rock and roll with your bad self. I will always support you defending yourself.
Daddy, I punched him a lot.
Yeah, it was Daddy, I punched him a lot. Okay.
Okay.
Rock and roll. No. 500, if someone wanted to say all the racist shit they ever wanted to say walking down the middle of Main Street, it's just words. Now, if they get their ass kicked for it, am I completely against that? Nah. There's a little bit of deference to that. But if they're just saying words and they don't attack anybody, they don't use force against anybody, then let them say what they want. That's so you know who they're at. Then you know who they are. You know where they're at. Those are. I don't give a shit about those people. However, if they get punched in the face for saying racist shit, they just kind of had that one coming. The person punching them in the face, however, control your temper. to me, it would be kind of a misdemeanor. I'll buy you an ice cream cone. You pay a $25 fine, and that dude gets to deal with a broken jaw situation. But yeah, speech is speech. Speech is not violence. The only reason you should be able to say anything about my speech is if you can directly connect my speech to a call to violence. Me saying, hey, we're going to go kill all the crackers. And I'm inciting that, and then yes, you can connect me to that. If I say I don't like these white people, no.
Cool,
you
can't. Me neither.
Yeah, fuck, I don't like myself. So yeah, just doesn't matter to me. If the speech was actually connected like that, then people like Louis Farrakhan and others who have talked about kill Whitey, bury him, dig him up, and kill him again, well, then they'd be in prison. And I really don't give a shit about those people. Until you try to kick in my door and actually make that a physical event, I don't recommend that for your health. But yeah, I really don't care. I don't. It's why I'm against the hate crimes. Does it really matter to the person that you murdered why you murdered him? No, they're just as fucking dead. Charge them for murder, keep them in prison for murder, and then call it a day. Why do I feel like it?
Fighter pilot.
Yeah, I want to fighter pilot. Yeah, goose. I'm just saying.
Yeah. Paint this white and then the red.
Make it look like Bane's mask.
When a law
is
enacted,
a good option. That's a good option.
Deals with gun regulation and implicates the Second Amendment, there's no requirement to make an allegation that the Second Amendment
hate crimes or thought crimes.
Upon.
I think that I agree that is their position, but I don't think
I don't
think that's consistent with Bruin. I don't, because that would mean that any regulation on firearms whatsoever, you automatically get to the historical inquiry, and that
bingo
plain text inquiry or the plain text analysis needs to do some work. It is a threshold. Otherwise, things as commonly understood and accepted today, such as background checks, you automatically get to the historical inquiry, and that that just can't be right under Bruin, because that would be inconsistent with what Heller, McDonald, and Bruin all said, that the Second Amendment is not a right to keep and bear any arm whatsoever in whatever place you want.
No, that is,
so the plain text
that's not what
does
they
need
said.
to do some work. And Bruin also,
and there's another reason I say Heller was
immunized plaintiffs
fucking
asserting
bullshit
Second Amendment
opinion
claims for meeting their Twombly-Iqbal plausibility standard. But even if we get to the historical inquiry, I'm getting close to my time. I want to be sure I touch on the historical inquiry if this court were to reach it. I think we've more than met our burden there. And plaintiffs make a couple arguments as to why, but I think their argument about the historical inquiry is inconsistent with what Bruin asks us to do. Bruin asks us to see whether the modern law is comparable in the how and the why to a
No, Bruin asked you to find a historical analog, not a direct text of a law, but a historical analog of a modern gun law. And the only thing that you guys can bring up is the 1783 Mass Act, which I got that out of another California case. And all that proves is the fact that people at the time, 1783, owned cannons and mortars and swivel cannons and muskets and grenades and basically every implement of war they could possibly own. That's all that proved. And then racist cases to where, hey, Indians can't own guns, them damn Indians, we got to disarm them, or black people can't own guns, or hey, these Catholics can't own guns. So the only so-called analogs you can come up with for gun control are based on race and religion. Good job, you bigoted bastard. Thanks for supporting that. But they argue these things so intellectually dishonest that it's just not fucking funny anymore. And I've only got a couple more minutes before Crump and them start. So let me let this roll, and then I got to get out of here.
Historical tradition. And we use the analogs to establish a historical tradition to the extent that there is not already an established historical tradition, like sensitive places that's established. And that is one of the ones we rely on here. And we pointed to analogs from the colonial era, the founding era, the post-Reconstruction era, from various jurisdictions.
The brackets for the four-wheeler gun mount was a four-cornered bracket that was kind of divoted in the middle and across section.
Of gunpowder in certain locations. We pointed to analogs that restricted the carry of firearms in specific locations. And we pointed analogs that are about fairs in particular, and pointed to analogs that are about places.
Sorry to burst your bubble, but
where large people or large groups gather.
I bursted that entire
bubble. Plaintiff's cabining of the historical analysis to only the founding era is really a caricature of Bruin. And Bruin made clear in the majority opinion and in Justice Barrett's concurring opinion that that is not what it was deciding. It was not deciding between 1791
and until my beliefs become physical,
I think what
and they wrongfully
consistency across those eras,
wrongfully deprive you of life or your property.
Analogs,
my beliefs don't matter.
In the post-Reconstruction era, it was because they were inconsistent with the historical tradition established at the founding. And to the extent, we don't think there's legislative silence here, but to the extent plaintiffs think there is,
silence
that
is
cannot
violence.
be dispositive in the historical inquiry, because there are many reasons why the legislature may not have acted. And I think the Central District Court really erred in applying its the historical inquiry, because it did demand a historical twin, which Bruin tells us is not what is required. For the public property or government proprietor tradition, it erroneously injected the First Amendment analysis into the historical inquiry. And then for the sensitive places and regulation of firearms commerce traditions that we identified, the court demanded a historical twin and said that we did not identify
these government actors always
firearms at a place like the fairgrounds.
Argue.
So
we win, you
don't
lose.
Need to identify.
We're playing a game of hide and go fuck yourself.
The
You go fuck
1825
yourself.
New Hampshire law.
That's how they argue.
That restricted the sales of gunpowder at certain locations where large groups gather, such as highways, streets, fairs, not fairs, parades, commons, wharfs. And plaintiffs even acknowledge that is a quote genuine analog. And so I think there are multiple errors in the historical analysis that the Central District Court committed, and I think there are multiple errors in the historical analysis that plaintiffs asked this court to engage in if the court were to reach the historical analysis. But again, our top line position is that the court does not need to reach the historical inquiry, that whether it's under Twombly-Iqbal pleading standard, or whether it's a plain text step, plaintiff's Second Amendment claim does not get to the historical inquiry in both Central District and the Southern District case.
100%.
Unless the court has any questions,
You have one. But I've carved out ammunition because I hadn't contemplated the impact of not having a waiting period. I'm not sure the analysis is any different. I take it your understanding of the California statute, just as it would preclude the acceptance with regard to a firearm purchase, it would preclude the acceptance with regard to an ammunition purchase. The only difference is that the firearm isn't going to get delivered till after the waiting period anyway, and there's not a waiting period for ammunition. Is my understanding of the state's position correct?
It's correct that these laws would prohibit the payment for the ammo, and then which then somebody can then walk away with the ammo. So that is the work that is being done for the purpose of ammunition purchases. These laws also restrict the sale of firearm precursor parts. And just to clarify for the court, firearm precursor parts, there's a law that generally prohibits the sale of firearm precursor parts across the state. That law passed pretty much at the same time as SB 915 and after AB 893 and SB 264. So the firearm precursor parts restriction isn't doing any work. It's the firearms and the ammunition restrictions, because
not doing any work with regard to the fairgrounds or state property. Has it been the subject of challenge yet with regard to applying it elsewhere?
It was a subject of a Central District challenge that the Central District Court rejected at the plain text step. I'm sorry.
Our court hasn't been
No, because after the rejection of the claim, then the claims are voluntarily
I
dismissed.
do
In
believe
that case,
the lawyer for the plaintiff,
Bonta, which is cited in
whatever, she
one of our
gets to come
briefs,
back up
especially with
after
our
this,
opening
I
brief
think.
in the Central District and our answering brief in this case. I did also want to clarify for the Southern District case, there are a series of immunity holdings that the district court made that plaintiffs don't challenge here. And so the court found that Governor Newsom and Secretary Ross were immune from the claims, and plaintiffs don't challenge those holdings here. And so just in my last few seconds, I'll just say that I think these are both pretty straightforward appeals that can be resolved by looking to existing Ninth Circuit precedent, and the court doesn't really need to break new ground here. And that is what the Southern District Court did when it rejected the claims and gave the plaintiffs an opportunity to amend their Second Amendment complaint, which they then declined. And we think that the Central District Court made multiple legal errors across the First Amendment and Second Amendment analyses, which then bled into the equal protection analysis.
Wayne LaPierre,
so
man.
we think the preliminary injunction in the Central
If you
District
took the money he spent on suits and put that into litigation, we wouldn't be here right now.
I'd just like to make 4 quick points and then wrap up for your honors. With regard to the dispute over sales, the problem with leaving the definition and interpretation of the law up to the state to interpret its own law is that
I got to stop her right here just for a second for an observation. She has such a sweet voice, but she is making an absolute stone cold argument. She looks like the one who would ask you to take the trash out and have you crying in tears later, and never change her tone of voice.
this makes it still subject to a vagueness and ambiguity
If you were married to her.
issue. So it is still a First Amendment issue, which I think has been on display today over the parties' disagreement over what the law means. And it's also probably why the fairgrounds, both in Orange County and Del Mar, refused to contract with my client because they couldn't figure out what sales were. And again, sales definition is specifically at issue because this is about firearms, right? Firearms in California, sales.
I don't think she was.
The legislature in California has defined sales as a bifurcated event. Offer, acceptance, and consideration happen at gun shows. The finishing of the transaction, the actual exchange of guns happens 10 days later, off premises. So the only thing this law could be banning, if we're going to interpret the law to mean anything at all, is that the speech of offer and acceptance are being restricted. I want to briefly touch upon Teixeira and its ability to survive Bruin. The plaintiffs appellees and appellants in Orange County suggest that there is a holding from Teixeira that survives, and that is there is a right to acquire firearms and ammunition necessary to the right to arms. What doesn't survive is the sort of historical analysis that the court took in Teixeira with regard to finding that there's no freestanding right to sell firearms unconnected with purchase. And that's because it was a sua sponte historical analysis that was conducted. It was not something that the parties created. And the court improperly shifted the burden to Mr. Teixeira to prove that his conduct was being protected under history and tradition, instead of demanding that the state establish, the government established that its restriction fit within this nation's historical tradition of firearm regulation.
And whenever the state has a charge,
ultimately, the momentum in courts of this circuit is that this court is that First Amendment and Second Amendment do protect gun shows, at least to some degree. The only case that is an outlier is Judge Battaglia's decision in the Del Mar motion to dismiss hearing, and it should be overruled.
Thank you very much. We thank both counsel for their very helpful arguments this
so that's
morning.
the end of the arguments for tonight.
And we are in recess until tomorrow morning. Thank you.
He slapped that gavel awful hard. So yeah, let me kill that. And for you guys, let me find it again. I think I still got it up. Yes, I can get it up. Well, maybe I don't still have it up. Damn it. Hold on. I'm going to throw a couple things out there. So, Legally Armed America. Apparently, I missed his Yeah, dude, I'm fixing to get out of here, Trev. I got to do pretty much the same thing. So, and I'm going to post a couple links real fast. Legally Armed America just threw his stuff up. Go check Legally Armed America out. Make sure I'm in the right. There's so many freaking links I can throw out right now. But check out Legally Armed America. Legally Armed America, Paul over there has a lot of really, really good content that's on point. And let me throw Crump out there. From Crump, you can get to DLD, you can get to Flying Rich. Follow these guys. They're fixing to go live at 9. A fundraiser. Saw Haley finally dropped out. Yeah. Haley finally did drop out. Let's see. Hold on. Hold on. I'll throw Rich's out here too, and then I'll see if I can find Darks real fast. Ooh, damn it. That's not what I wanted to do. You hate it when you hit the wrong buttons. So this is Brother Flying Rich. Check Rich out. Rich is another cool dude, which most of you guys all know him. And then let me find Dark real fast, because all of them apparently are doing the stream tonight for Bella. Here's Dark. I should be in chat for at least some of this. If you guys aren't following Rich and Crump and Dark, I don't know what you're doing with your lives, but you need to unfuck yourself and follow them, because these are all really good guys. Crump does a lot of writing. Dark does a lot of really freedom-centered stuff, and so does Rich. All really good guys, really solid people who believe in freedom. And like I said, they're going to go live in about 8 minutes now. So check these guys out, follow them, get on there. Tread, I'll check that link out. Live at 5 News, lawmakers reach compromise, harmless carry bill. Hold on, let me pull that up. Where's my actual stream at? And let me hit that and pull it up, and I'll watch it. South Carolina. So yeah, they did their South Carolina did their hearing. What was it, day before yesterday, or was it yesterday? I'm losing track of days here. So they had their committee hearing the other day with the whole thing. Yeah, I know, Trev. I just pulled it up. So basically, the House and the Senate had their joint committee. They went over all the amendments. They kind of finalized everything and said, okay, this is a bill we're going to put out. House will vote on it. Senate will vote on it, and then we can send it on. We'll see how many House Republicans actually try to put amendments into that. Hopefully, and Night Strike will be one covering that, probably more than I will. Hopefully, since the House and Senate got on the same page now, they'll go ahead and pass it to the House, pass it to the Senate, send it to the governor, and the governor can sign it. And it may be a couple of weeks, depending on when hearings are held. But hopefully South Carolina will have their constitutional carry within the next, we'll say, month. I'm not sure when exactly their sessions run, how long they run, but we'll say the next month, hopefully. These guys could literally pass this in under a week if they wanted to. They could run it that fast. They could clear calendars and run constitutional carry all the way through and get it to the governor in no time. But we'll see exactly what they do.
Can you
Watch
check
out.
the weather, please?
Can I check the weather? Why did I check? I got to check it for my classes tomorrow. But why am I checking the weather for you?
Because I don't have a laptop, so I can't check the weather.
But why do I have to check the weather for you? Your school has a roof on it. It's not like it's going to be raining tomorrow and you can't go to school.
Can you at least check the weather to make sure it's
I'm
not
going
raining?
to check it in a little bit, okay?
Okay.
Get out of here. Do you have all the toys out of my living room yet? Still? Okay. So anyway, that's where we're at. Like I said, Crump, Dark, Rich, all fixing to go live in just a couple minutes. Not sure on the reload. Sounds like constitutional open carry. It's a little bit tread. If they pass the bill in its current form, I think you guys will be good with actual constitutional or permitless carry is what it comes down to. I think you guys will be good. Will it be as good as Alabama? I don't think so, but it will at least be close. You guys won't have to worry so much. So we'll see what. Hopefully, if Night Strike doesn't cover it, I will break my neck to try to cover it concealed, because South Carolina already has open carry. So what we're talking about now basically is permitless concealed carry, and there are some things in there that will affect the open carry, but we'll have to see what amendments they try to push in once they actually get this bill back out on the House and back to the Senate, and then of course the governor signing it. So if Night Strike doesn't cover it, which he should be, he's in South Carolina, that mofo, he should be covering it. And if he covers it, I might be on his stream some. If he doesn't cover it, I will break my ass to try to cover it myself. The story read like it was not, or like it was open, not concealed. No, the permitless carry is going to be for the concealed. They already have open carry in South Carolina. Sorry, my wife is like putting oil. You dirty bastards! Don't even think that.
Get off the stream. I'll do whatever you want.
Don't tell me that. But yeah, so, and I'm fixing to. I'm trying to end it. So anyway, but yeah, the South Carolina is all about the permitless concealed carry, because you guys already have open carry in South Carolina with some goofy shit about happening in your vehicle and other things like that. So we'll see what all the amendments add up to. That's going to be the big thing is them getting it through after they've already consolidated everything in the joint committee, what it looks like when it hits the floor again. And I'll try to keep an eye on that. And then, of course, hell, there's plenty of shit going on all over the country. Minnesota, I haven't even touched on Colorado going nuts. Virginia's going absolutely insane. We'll see what the governor of Virginia does with a lot of their stuff. So we'll try to keep up with it. And of course, if anybody in the chat, if you got something going on in your state you want me to cover, send me some info on it. Let me track it down and we'll cover it. I'm off work for 7 days Friday. A cool deal. Yeah, that's if we do an actual constitutional amendment for 500. Yeah. That's if we do an actual constitutional amendment. Anyway, let me get out of here, perps, because John and everybody's fixing to get going, and I got to get out of here because I'm going to be in their chat. So follow John, follow DLD, follow Rich. Get over there to their chats, hang out. If you can't, if you're like me and you're a broke bitch and can't necessarily maybe support something right now, share it out. That way maybe you can get it in front of someone who can. This is about Bella's wish. I'm going to learn to talk one day. I swear to God, I'm going to learn to talk. I can still talk better than Biden, so fuck all y'all. I do this shit without a teleprompter. Anyway, let me end it like we always do, man. You perps be cool. I'm going to show you my wife's gun tonight. You guys keep that thing on you at all times. I love all you guys to death. Let's go support John and Dark and Rich and Bella. let's get in there, guys. The links are in the chat. Support armed attorneys, follow them. That's in the chat too. Legally Armed America is another good guy to follow. He's down in Louisiana. Follow Paul. And let's get in there and darken everybody. Most of you guys or a lot of you guys are there anyway. Let's get in there and goof off, raise some hell, have a good time, shoot shit. And again, I'm out, guys. I love all you guys to death. And we're done. Kind of, sort of, maybe. Till next time. I love you guys, man. Y'all take them easy. We'll see you in the chat.